Thank you for joining us for single asset real estate cases. My name is David Levy from Summit Investment Management and Keen Summit Capital Partners in Chicago, and I will serve as today's moderator. This webinar is the third part of the Financial Poise webinar series, Ethical Issues in Real Estate-Based Bankruptcies. Slides 7 and 8 provide a summary of the episode and series. Episode number 1 covered valuing real estate assets. Episode 2 covered insider lease agreements. And this, the third and final episode of the series, of course, is about single asset real estate cases. Speaking of the slides, you should understand from the get-go, we will not be running through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the PowerPoint handy, however, because I will try to indicate which slides our conversation is touching on as we proceed so you can take notes. Our panelists today are Samantha Rubin, an attorney from Denton's in Chicago and a member of the firm's restructuring, insolvency, and bankruptcy practices. Matthew Christensen, an attorney from Johnson May in Boise, Idaho. He is a member of the firm and practices bankruptcy, real estate, civil litigation, and other business matters. And lastly, Mark Silverman, an attorney from Troutman Pepperlock in Chicago, and the firm's commercial mortgage-backed security, also known as CMBS, team leader. Again, I'm David Levy from Summit Investment Management and Keen Summit Capital Partners. Keen Summit provides real estate services like real estate brokerage, auctions, lease restructuring, and more for bankruptcy and other situations. Our sister company, Summit Investment Management, buys all kinds of distressed debt and provides bridge and bankruptcy financing. We appreciate you're not spending your time and money to attend this webinar to hear infomercials about us, but you can read more about us in slides 45 through 48. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand and have questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get you an answer. Lastly, special thank you to our sponsors of this episode, National Law Review, a premier legal news website, and Max Asset, a simpler, easier way to conduct asset sales. Okay, and with that, away we go. So today, of course, we're going to have an important conversation about ethics and specifically ethical issues in single asset real estate cases, which are commonly known as SARE cases or single asset cases. Our esteemed panelists will speak from different perspectives based on their professional background. Samantha Rubin from Denton's works with both debtors and creditors. Mark Silverman from Troutman Pepperlock specializes in creditor and lender representation. And Matt Christensen from Johnson May covers a variety of practice areas inside and outside of bankruptcy. So let's start with a good warm-up question and begin with the key questions. What are ethics? What are legal ethics? Samantha, start us off.
Sure, thanks, David. So ethics can be as simple as a gut feeling where you know something is a little bit off, or they can rise to a level of legal liability, such as fraud or fiduciary duties. And ethics are really important because they're designed to protect the client's interests. And as we'll discuss in a little bit, lawyers are bound by a set of ethical obligations in the model rules, the ABA model rules of each state that a lawyer practices in. And so, it's really important for lawyers to follow those rules. And sometimes you have real estate business people, real estate professionals who may be lawyers, non-practicing lawyers. And so the lines as to their duties can sometimes be a little bit blurred and complex and gray, as we might discuss a little bit later.
Thanks, Samantha. Matt, what do you think?
I agree with Samantha. I mean, it's sort of what choice do you make when you're the only person looking at your choice? It's obviously going to affect clients and that sort of thing, but what's the right decision to make? And I think when you get into legal ethics, of course, there's a whole framework of rules that may apply to some of those choices, but generally speaking, it's what's the right thing to do.
Mark, what do you think?
Doing the right thing when no one is looking, which I think is what Matt and Samantha were both getting at. But I also look at it as the golden rule is also very helpful. Do unto others as you would like to have done unto you. That's a good guiding principle as well when you're dealing with ethics. And I think that from my standpoint and from where we sit in representing clients zealously, this is never going to be an issue if you're constantly focusing on just doing the right thing. And you can still zealously advocate, you can zealously represent without being dishonest, without being deceitful, with doing what you say, with saying what you're going to do, and not hiding the ball. And I think that in real estate, it's always tough because I think you have a lot of folks that operate in real estate that might operate in the shadows of life, and that's okay, that's their prerogative. But as lawyers and as folks that are going to practice on the ethical side of things, it's important to keep our head above that line and above the water.
These are all great perspectives, Mark. It was a great lead and made me think of my example on this topic as the non-attorney, as the real estate and distressed finance professional who's active in the Turnaround Management Association here in Chicago. And I recall a really fascinating program we once had with Andrew Fastow, who was the former CFO of Enron. And he was such an interesting presenter because he was talking about how the exact same set of activities that he did, which were approved by his board and his law firm and his lenders, won him both the CFO of the Year award and also this federal prison ID card that he held up. And his point was that each of these individual acts weren't just legal, but he was constantly being told that he was doing a great job and he was really, really smart. But he knew that the cumulative effect of all of these individual actions was creating not only a lot of deception, but also fraud. And therefore, not only was it unethical, but it was also illegal. So all important things to keep in mind. And of course, the American Bar Association provides a framework for how to deal with ethical questions called the Model Rules. There are quite a few of these, but during this program, we're highlighting Rules 1.7, conflict of interest, Rule 3.1, meritorious claims and contentions, and Rule 4.3, dealing with unrepresented persons. So Mark, talk to us about how the Model Rules influence your practice.
It impacts every single interaction every single day. And it's the constant guidepost that each of us are responsible for, not only for ourselves, but for our teams. So when you're running a team and you associates and other partners, and overseeing their work, it's important to make sure that things are always being done in line with the model rules and with the ethical canons. It's more important than virtually any other thing that we deal with. And it's important, especially when you're dealing with a lot of folks in the real estate space, to make sure that they understand where you are bound and where you are not bound. So for example, if they're asking you to reach out directly because they want to move fast and they want you to reach out directly to this guy because they know this guy really well and they know that he'll respond, that's great. We're still not going to do it because he's represented by an attorney and I can't get a hold of the attorney right now, but I know that this attorney will get back to me at some point in the future. And so just because you have an antsy client doesn't mean that we can violate our ethical canons by going directly to, for example, a person who's represented by an attorney. And so making sure that you have enough gumption and enough confidence in yourself and in your practice to be able to tell clients when they are pushing you in a direction that is not going to benefit their case and is going to put you in hot water is of critical import. I would rather lose a client than my law license. So it's always going to be something that sits on the top of our minds as you go in and out of your day-to-day practice.
Good perspectives. Matt, what do you think?
I'll echo what Mark said and just add one little extra piece. The model rules from the ABA are just that, they're model rules. The rules that actually apply are the rules that your individual state bars or local bars adopt. So if you've got a multi-jurisdictional practice, sometimes there are differences between the rules that have been adopted in one state versus a different state. And so if you do have that broad of a practice, just understanding where those differences are, because what may end up being okay in one state is maybe crossing the line in a different state. So just know that there are some differences. I would say 97% of the rules are pretty uniform state to state, but you don't want to find out the hard way that you fit in one of those 3%.
No question. And Samantha, give us your thoughts.
I agree with what Matt and Mark have said. You know, I think from the moment that you open up a matter, you know, when a client asks you to represent them, you have to analyze these rules. And thankfully, we have a conflicts department that does a lot of that for us. But really, we have to, you know, be in touch with them and tell them who the adverse parties are, you know, and it is like a gut check. It is sort of a, does this have an appearance of a conflict too, rather than just a legal conflict under the model rules or even the bankruptcy rules, which you have to look at too, both for you and your client.
Well, Samantha, let's stay with you for a moment. One of my signature pet peeves as a moderator is when we use terms and we take it for granted that the audience all knows what those terms mean. So I want to start by covering a couple important ones, which are single asset real estate cases and the automatic stay. Could you please review these for the audience?
Sure, David. So in its basic terms, a SARE case is one where the entirety of the debtor's business is related to the ownership of a piece of property or a project. And so generally there's only a handful of creditors in a SARE case. You have the secured lender who's, mortgaged, it's secured by the property and makes up a majority of the debtor's debt. Maybe you have a couple of secured creditors, but one of the most important things to know about a SARE case is that there are multiple restrictions in the Bankruptcy Code, imposed on SARE debtors, particularly that the automatic stay may not be in place for as long as normal in a normal bankruptcy case. And so for non-lawyers, the automatic stay is essentially a pause where as soon as a debtor files bankruptcy, actions to collect debts are paused and you cannot proceed with those, except through the bankruptcy case. And so, after the debtor files a SARE case, they have a certain amount of time that the automatic stay is in place. A secured lender can dispute the SARE filing if they don't think that they are actually, fit the mold for a SARE case. Or they could seek relief from stay if the debtor, unless the debtor does one of two things. First, they have to file within 90 days of, commencing their case, which is pretty quick. They have to file a plan that has a reasonable likelihood of being confirmed within a reasonable amount of time, or they have to start paying the secured lender at the non-default contract rate of interest. So those are important, particularly the payments, because if the property is not cash flowing, that could be, difficult for a SARE debtor.
And I wonder if you have any thing else to add to that, just overall, what roles the single asset real estate case status plays in bankruptcy cases.
Sure. So, what sort of sets these apart is that, from normal bankruptcy cases where you have, hundreds, thousands of creditors, here really it's a two-party dispute between the debtor that files bankruptcy, that owns the property, and the secured lender. And so this can lead to bad faith filing litigation or plan disputes. Like I said, the secured creditor can try and foreclose on its collateral within 90 days of the case. And that could be difficult for the debtor if they're not cash flowing or the business is really not viable. So they can't count on the automatic stay to, remain for a long period of time. And, as the case law shows, not every owner of a piece of property is going to be a SARE debtor. And courts have continued to narrow that definition. So before you file a SARE case, it's really important to take a look at the facts. And we'll talk about some case studies later on about, the contours of what constitutes a SARE case. But what constitutes a single asset real estate project can be complicated.
Thanks, Sammy. And now let's talk about the sides of that matter. Mark, what are some things that the debtor, lender, and judge care about in these single asset real estate cases?
Absolutely. So I think something that Samantha mentioned is really important, and I have kind of a short quip for it, but it's, you see a single asset real estate case and you have 90 days to plan or pay. So if you can kind of think of this 90 days to plan or pay as your mantra when you're thinking about these single asset real estate cases, it's a very helpful little moniker. But for me as a creditor's lawyer, one of the first things that we're looking at is, are we oversecured? Are we undersecured? How are we looking at this case from an adequate protection standpoint? How are we going to get paid? What does the budget look like? Is it an over bloated budget? Are they including professional fees and management fees that are going to insiders? Kind of where is all the money flowing? And then obviously with a lot of these large office towers, you're looking at insider leases too. So there's always, it would seem to be these sweetheart deals where you look at and you go, that's not even close to market. This doesn't really make any sense. And then you dig a little bit deeper behind the LLCs that are the tenants and you find out it's somebody's brother-in-law's sister's best friend. And you now have an insider lease that you need to deal with. So I think that from a creditor standpoint, those are the things that we're typically looking for at the very outset of the case. When you're a debtor, the most important piece when coming into this is, what am I looking to get out of this? If you're going to file a single asset real estate case, and Matt, I'm sure, can talk about this a little bit more, you better have a pretty good plan as to how you're going to get out of your single asset real estate case. Otherwise, you're spending a ton of money in legal fees and professional fees, trustee fees, court fees, and everything, and you're going to get to the same place that you would have gotten to outside of bankruptcy. The automatic stay is certainly not something that as a creditor's lawyer we look at and say that this is something that's going to be in there forever. If we look at this case and we find that we're significantly undersecured, or that it's a bad faith filing, or any of the other number of things that Samantha raised, we're coming in very early in the case and seeking to modify the stay, seeking to dismiss or convert, or seeking to convert to a liquidation in some significant way. So there's not a lot of time. And so if you're a debtor and you're going to file a free fall type SARE, good luck to you. If you're dealing with savvy creditors counsel like Samantha and I on the other side, you're going to, you'll be toast.
Thanks, Mark. All of this is going to make a lot more sense if we put it into some case studies. So we've prepared a few different ethical situation case studies to discuss, and we will advance it to slide 20 and kick off the first one here. Case study number 1 is regarding Orchard Hills Baptist Church. Orchard Hills Baptist Church, we'll just call them the church, operated a single Baptist church in Noonan, Georgia. In 2007, the church borrowed $3.8 million from Branch Banking and Trust, at the time was known as BB&T, on a 3-year term to construct a new building for its congregation. BB&T secured the loan with a mortgage on the property and in other minor assets of the church, in addition to a personal guarantee from a well-known real estate developer associated with the church. Over the years, as the church struggled financially, the loan was modified several times and the balance reduced to about $2.7 million. In 2018, after 21 months of forbearance, BB&T sold the loan to Summit Bridge National Investments. We'll call them SBN. In 2019, SBN entered into a new forbearance agreement with the church requiring monthly payments of $100,000. However, the church missed the first payment and SBN filed for foreclosure. On the day the foreclosure was scheduled to occur, the church filed bankruptcy. SBN, among other motions, moved for dismissal of the case for cause. In the 11th Circuit, a case can be dismissed for cause if the debtor files in bad faith, which requires a finding of bad faith by the debtor with an intent to abuse the judicial process after weighing the totality of the circumstances. The court ruled while many factors favored SBN, the church did not file the case in bad faith. Weighing towards a ruling in bad faith were the findings that 1, the church is essentially a two-party dispute. In this matter, it's essentially a two-party dispute between the church and SBN, its foreclosing lender. 2, the church's primary assets is the property that is the subject of the foreclosure. 3, the church has no other secured creditors and few unsecured creditors which hold limited debts. And 4, the church filed for bankruptcy on the day of the scheduled foreclosure sale. Weighing more strongly against a ruling in bad faith in the opinion of the court were findings that 1, the filing was the church's first bankruptcy. 2, SBN made no allegation of improper conduct by the church prior to the filing. And 3, the creation of the church of an automatic stay by virtue of the bankruptcy filing was not sufficient on its own to indicate bad faith. Interestingly, the court declined to dismiss the case. The court did grant SBN relief from the automatic stay based on its finding that the church owed more to SBN than the value of the property. So Mark, if you could, first off, please define what a bad faith action means here.
Yeah, absolutely, David. I think you kind of did it in the overall body of the prompt, but it's effectively when you use the bankruptcy process improperly to defraud creditors and to abuse the system, and really not putting a case forward to actually deal with the debt and find a way to restructure the debt, as opposed to just simply throwing up your hands and asking everyone to stop bothering you in state court or other foreclosure proceedings. They typically are more successful, whereas the prompt dictates here, where it's on the eve of a foreclosure auction, we see them on the eve of receivership. And so a lot of times we'll be putting in a receiver and asking the receiver to take possession, control of the property and all the rents, issues, and profits of the asset. And right as we're heading into court, we get a notification that the debtor has filed for bankruptcy, which obviously stops the receivership from ever getting put in place. Our view in general from a creditor standpoint on a bad faith filing is it should always be something that's evaluated, but never something to hang your hat on exclusively. So we're not typically going to advise clients to file a single motion to dismiss based on the bad faith filing because it's really hard to prove. And as the prompt indicates, and as the creditor learned in this situation, they probably had better arguments in the relief from stay and in the potential conversion of a case than simply to go down the path of a bad faith filing. I'm of the view that whenever you're going to be dealing with stuff that's incredibly fact intensive, you want to have that as your secondary or perhaps tertiary plan, as opposed to something that's more easily achieved based on the black letter law or based on some significant fact that's a effective silver bullet. And so bad faith filings are incredibly fact intensive. And even when you have a significant volume of facts that are going to stack in your favor as to why a case should be dismissed because it's a bad faith filing, I still am not entirely convinced that courts love to give that to creditors, especially right at the outset of the case. So as Samantha stated at the outset, 90 days is a really truncated amount of time. And so if you're going in on a single asset real estate case because of a bad faith filing, the judge is going to likely give the parties some breathing room to see if there's a plan that can be put forward that could pass muster. And at 90, they're going to tell us, like, you're at counsel, 90 days, it's nothing. You can't get a foreclosure done in 90 days. So we may as well see if they can put forward a plan that's going to work. And look, now they're coming to you with requested adequate protection payments. They've put forward a budget. Let's get some feedback on that. Or as I did in this prompt, they'll say, go back to state court. We can still deal with the debt here, but go enforce your lien rights in a state court or federal proceeding.
Well, it was funny. When working in real estate bankruptcy, I kind of joke that as the non-lawyer, there seems to be a limited number of circumstances where you're going to have a true restructuring in a real estate-based bankruptcy. And I joke that it's probably correlated to the number of floors in the building and the number of line items on the P&L. So a skyscraper and a full-service hotel. But nonetheless, these 11th hour filings, I think, are fairly common. So this is a great topic for one of the three parts of this series. And I'd like to dive into a little bit deeper, Mark, given the fact pattern here, more broadly, what do you see as the ethical issues in play and how we ascertain what's shady versus shrewd when filing a single asset real estate bankruptcy?
Honestly, here, I don't see any ethical issues on the debtor side at all. I think they played this one correctly. I think this was something where there was obviously a strategic reason for them to file, and that they're probably doing this more or less in good faith. The timing of it is frustrating from a creditor's perspective because you're telling your client, hey, we're going to sale. We're going to sale on Friday. This is going to be great. We're going to finally be able to get this thing off the books. This is going to be fantastic. Now we've got another year of bankruptcy work that's going to need to go into this. That's frustrating. I don't think that there's anything here that scratches on the unethical side of things. And I do think that this is an effective use of the bankruptcy process from the debtor standpoint. Well, on the creditor side, mostly, it frustrates me to no end. I don't think there was anything here that's screaming out in bad faith. I think you start to get there more on the receivership side of things than you do at the foreclosure sale, because the receiver is a stutter step. Most of the loan documents, if not 100% of the loan documents, allow for the appointment of a receiver or the taking of a mortgagee in possession during the continuance of an event of default. And most state law allows for you to then pursue a receiver during the pendency of that default. So when folks file at the receivership part of the case, I find that to be a little more questionable than at the foreclosure sale, which is the ultimate conclusion, borrowers losing out on equity, et cetera.
Thanks, Mark. And in honor of March Madness, thank you for incorporating stutter step into your explanation.
You got it, man. I'm here for you, David.
Thank you so much. Samantha, what do you think? What are some of the ethical issues in play here?
I agree with Mark. I think one thing, just given that the automatic stay, they granted relief from stay to the secured creditor here. If I was the debtor's counsel, I would want to counsel them about all of the options that that could happen, or the outcomes, that could happen during the bankruptcy case. For example, maybe relief from stay will be granted. You might be considered a SARE debtor, but here they did miss the first payment of $100,000. There was concern that they could even make payments during the bankruptcy case. So we can assume that they're already having financial difficulties, and so that they might have difficulties in the bankruptcy case too. So just counseling the church as to what the outcomes are and, you know, that they're gonna have to file a plan quickly or start making payments.
Thanks, Samantha. Matt, what can you add to this?
So the fact that kind of sticks out to me on this is the timing of the bankruptcy filing versus the foreclosure sale. So frequently representing debtors, I don't necessarily find fault in the timing, filing the right before the bank or foreclosure sale happens all the time. But I'm for my clients, my advice to them is usually, look, if you can work out something with the bank, do that. Bankruptcy should be the last thing you file. It's because of the huge impact that Mark described. It's going to cost you a lot of money, that you may have a creditor that's going to come in and file motions right away. You got to deal with those. So what's interesting to me is the timing of the filing versus the timing of the default. So they'd been in default for a while, 21 months of forbearance before the loan even got sold to SPN. Then SPN does a new forbearance agreement, maybe a few months or a year after it gets the loan. And the very first payment under that agreement is missed, right? So that payment is missed. Then the foreclosure process starts. Presumably nothing happens in the meantime. Eventually you get to the date of the actual foreclosure sale, and the day before that is when the bankruptcy is filed. So to the extent there's any ethical issues, which is sort of a stretch, I tend to agree with Mark that I don't really see any huge ethical problems here. But to the extent there is, it appears to me that there was a little bit of game playing in the timing of that bankruptcy filing. In other words, hey, we bought ourselves another 4 or 5 months while the foreclosure process progressed. Now we've filed the bankruptcy, maybe we can buy a couple more months till they get, or at least weeks till they get stay relief. And then, you know, in the meantime, we're getting some income. Well, it's not even income. They're operating their church. They don't have to move out. So that's the only sort of fishy fact to me. Does it raise to an ethical issue? Probably not, but it does look a little squeamish.
One quick thing before you jump back in, David, is that when you look at these types of single asset real estate cases, especially in the prompts that are leading up to this, as Matt said, if you can work out a deal with the lender to avoid filing for bankruptcy, if you're a debtor's attorney, that is absolutely in the best interest of your client. There is no question. We've seen so many times where if they had just responded to another turn of a red line on a forbearance, or if they had just made some additional proposal utilizing some of the funds that they had to pay their debtor lawyer in a retainer or in fees, that may have bridged the gap to get to a resolution with the lender. Instead, oftentimes you get back to the same or similar deal that you would have been able to struck pre-bankruptcy and not have to have filed the bankruptcy at all. And so the debtor has effectively spent money on attorney's fees, et cetera, to get back to the exact same place. And so creditors' lawyers, we're people too. We're super nice most of the time. Talk to us. And the constant pounding of the table and we're going to file and this is going to be end of times. See you there. Okay, great. The only people that are making money is your debtor's attorney, and you're going to still have to deal with us, still have to deal with the secured creditor, and now you're just spending a lot more money. So it's not an ethical issue per se, but it's a client counseling issue, and it's something that, especially, I know we're not talking about this, but if there's guarantors involved and you have potential recourse liability that gets triggered upon the filing of a bankruptcy, you're dancing the line on malpractice issues. There's a lot of other things that a debtor's lawyer needs to be looking at before they just say, we're really sick of you and we need to file a bankruptcy because we need a little bit of breathing room. That little bit of breathing room can end up being very expensive for your client.
And just to build on Mark's point a little bit further, one fact I don't think we've discussed in this case was that the brother of the pastor in this case had issued a personal guarantee on the loan. So I don't know that we really delved into how that came out in the bankruptcy case. He was like a well-renowned real estate developer. And the pastor had been the pastor since 1983. So there's obviously some personal relationships there, and who knows how that would have turned out in the bankruptcy case.
And what if we change the fact pattern a bit, Matt? We were talking about timing. This is a 2019 filing, and the judge noted that one of the points in the church's favor for not having a bad faith filing is they had not filed for bankruptcy before. what if they had filed bankruptcy in 2010? Does that change the calculus for you?
So potentially, I guess I was reading that as if instead of a 2019 bankruptcy, they had a 2010 bankruptcy that was filed. The way you asked the question made me
I
think.
think it was, I think the
Still in the
thinking was they had a
2019
history of bankruptcy. They filed in,
Yeah,
filed
we're
in
now in a
2012. and now
second bankruptcy case, yeah.
it's
And
22, as they
and I
say.
think, I think that matters. Well, I guess under either scenario, I think it matters. If you're in a 2019 bankruptcy and you had a 2010 bankruptcy, what was the outcome of that case? Did it get dismissed because it was a two-party dispute? If it did, and you just refiled again 9 years later and nothing really had changed, I think that's even worse for you for a bad faith finding. It's like, hey, look, we already found one time that you filed a case in bad faith. Now you did it again. That's an issue. So, but I think if the case we're talking about is the 2010 case, at that point, you don't have 6 more years of default, or I guess 9 more years of default and stringing along negotiations. I think at that point, it's even stronger to not be bad faith because you're not on the eve of a foreclosure sale. Your primary asset's still that thing. You still got a two-party dispute, but you've kind of run into bankruptcy court then, like, hey, look, we defaulted. We need to be able to restructure this thing. Was it a good idea? Probably not. But it because you could have negotiated something with the creditor outside of bankruptcy, you just kind of pulled the trigger too soon. But I think it's an even stronger not bad faith for that filing in 2010. I would say if the 2010 filing wasn't dismissed, resulted in a confirmed plan, they just weren't able to fully perform under the plan, then your 2019 case probably comes out exactly the same way. It doesn't really have an impact.
Thanks, Matt. Samantha, does this change your perspective at all?
I agree with Matt. I don't have a ton to add, but I would say, maybe we should look at the reason why that they filed in 2010. I mean, maybe it was for a completely different reason. I mean, I can't believe that was 15 years ago now, but that was just after the financial crisis. And so I think things might be looked at differently then. I also still question whether a church is a SARE in the first place, given just the definition of what a SARE is. So I think the court would still engage in a factual analysis like it did here.
And Mark, what do you think?
I have nothing to add except for if the fact pattern changed such that it was a late 2018 filing and early 2019 filing, you may not get the benefit of an automatic stay in a chapter 22 that's filed within that kind of year, 12-month mark. So it would be something that if the facts change slightly, you might be dealing with slightly different ethical issues and slightly different outcomes. I also wanted an opportunity to say that there was a chapter 22 for Forever 21. I thought that was kind of an interesting thing, and I think a missed opportunity for a headline. So if any of you are listening and have effects over headlines, chapter 22 for Forever 21, solid headline.
For sure. Samantha, I thought you made an insightful point about the nature of this bankruptcy. Is this really a single asset case? Is there a little bit more going on here? And so I'm curious, what if the church had 50 employees versus if the church only had 5? How does that change your assessment of the situation?
Yeah, so the more employees that this debtor has, the more likely it is that it's not a SARE case. So they had 5 employees, maybe operations are minimal, but if you have 50 employees, that shows there's substantial day-to-day services being performed, employment. For instance, if they have 50 employees, maybe they're running a preschool or some kind of school on the site of the church, which just shows there's operations ongoing, just besides like passive money, flow of money, which is more aligned with what a SARE actually is.
And Mark, anything to add to this portion of the analysis?
No, I agree. And that's typically in the context of most single asset real estate cases. A lot of times the employees are actually employees of management companies, not the debtor itself. And so that's typically how a lot of hotels will file, et cetera. But in the context of a church, I can't imagine that they would have had a management company that owned the employers or controlled the employees. So I think it does change the analysis and would probably potentially kick it out of a SARE.
Got it. And Matt, what are your thoughts on this one?
I don't really have anything to add to what Samantha and Mark already added. I agree with that.
Well, Mark, Matt, while we've got you on the floor here, we're all about the model rules in this presentation. So please discuss for us how model rule 3.1 meritorious claims or contentions would apply to this case study.
So 3.1 is the rule that essentially puts a little bit of onus on the attorney to make sure when they're advocating for a client's position that there's a good basis in fact or law for that position. Within the sort of civil rules, there's something called Rule 11. The model rule 3.1 is like the ethics version of Rule 11 that requires meritorious claims and defenses. So as far as how it fits in here, I think the facts as we took them, it isn't really implicated as Mark said, that there's not a huge ethical issue with the original facts. If we change the facts and there was a 2010 case that was dismissed for bad faith and now you're back in 2019 with exactly the same case, then maybe there's a Rule 3.1 issue. You know, what's changed that makes your case meritorious now when it wasn't then? And if there's nothing changed, then maybe that rule gets implemented. But it's essentially the rule that just says, like, you got to advocate for things that actually have some basis in an argument.
Thank you. Let's move on to our next case study here. This one involves another 11th hour filing in Fairfield TIC LLC. Fairfield TIC LLC, I'm going to move us up here to slide 25. Fairfield was a single purpose entity whose sole asset was a 66.2% tenant in common interest in a shopping mall in Virginia Beach, Virginia. 3 other entities owned the balance of the interest, and all 4 entered into a tenancy in common agreement governing control of the property. The mall owners, as co-borrowers, entered into a $30 million loan with a 10-year term secured by the mall. 10 years later, having struggled to find an exit strategy, the mall's owners found themselves $3 million underwater with a quickly approaching maturity date. A year after the loan was past due, after negotiating a deed in lieu of foreclosure from one of the other mall owners, U.S. Bank National Association, as trustee for the fund that now owned the mortgage, we'll just call them U.S. Bank, entered into foreclosure proceedings against the mall. 6 days before the scheduled foreclosure sale, Fairfield filed bankruptcy. In response, U.S. Bank moved for dismissal of the bankruptcy case for cause. In the Fourth Circuit, a case can be dismissed for cause if the debtor files in bad faith, which requires a finding of objective futility of the proceedings and a subjective bad faith of the debtor after weighing the totality of the circumstances. This court ruled that Fairfield acted in objective bad faith because the case was objectively futile, including that 1, Fairfield's only assets was its real property interest in the mall, which was fully encumbered by U.S. Bank's mortgage. 2, Fairfield was given a passive investor because the only source of income was its share of the net cash flow generated by the mall. 3, Fairfield was not a going concern because it did not meaningfully participate in the management of the mall. A management company was hired by the mall owners and could not access the cash flow and management of the entire mall to effect a reorganization. And 4, any plan of reorganization would require the consent and participation of the other mall owners, but Fairfield did not join the other parties to the case as debtors or show any likelihood they would cooperate. The court then ruled that Fairfield acted in subjective bad faith because 1, Fairfield held that only 1 asset and had no ongoing business income or employees to protect. 2, the case resembled a 2-party dispute between Fairfield and U.S. Bank because the few other creditors with potential claims were unsecured and in amounts far less than the amount owed to U.S. Bank. And 3, Fairfield filed bankruptcy less than a week before the scheduled foreclosure sale and after it had already lost motions to dismiss the foreclosure and an appointment of a receiver in state court. And 4, Fairfield filed without the joinder or consent of the other mall owners, knowing that their cooperation was necessary to effect a reorganization plan. Accordingly, the court dismissed the case. Okay, Matt, what are the ethical issues in play here?
So there's some factual issues that probably lead to some ethics questions. the ownership structure of this property, I think is potentially an issue. You've got 4 owners. Fairfield is, you know, maybe a majority owner, but there's 3 others that have a third interest in the property as well. And so from an ethics standpoint, what if I'm the attorney representing Fairfield, have I had communications with those 3 other owners? Did I inform them of the bankruptcy before it was filed? Obviously, once it's filed, I think as co-owners, they get notice. But was there any attempt to have conversations with them? Did those 3 affirmatively tell me they would not join in the bankruptcy filing? And so there's you know, conflict issues that may arise if they did actually inform us that they would not support the bankruptcy. Then maybe even get back into the meritorious claims. If owners of the property don't support it, then should you even be pursuing the bankruptcy? So that participation of the other owners, I think, is an issue. Another issue that arises, it sounds like there was a receiver appointed in state court because they lost that defense of that. So if the receiver's been appointed, what involvement did I, as Fairfield's attorney, have with the receiver? Was I adverse to him or her? Did they support the bankruptcy filing? And did I need their consent in order to even file the bankruptcy proceeding? So that's another issue. And then going back to the ownership again, the partial ownership of the real property, in my head at least, I'm questioning what the actual effect on the foreclosure process would be of only a partial owner filing for the bankruptcy. Arguably, maybe the foreclosure could still foreclose on the other 3 owners' interest somehow. And that's why I said I questioned it in my head. I haven't looked at it or thought deeply enough to say, no, that couldn't happen. But that's just something that sort of popped up is did I even really stop the foreclosure process by filing the bankruptcy? So those are sort of the issues that jump out to me.
Good
points. Samantha, what do you see as the ethical issues in play here?
I think Matt hit the nail on the head with a lot of the issues. I think, you know, I just want to elaborate a little bit on one of the points he made about how the interests of Fairfield and the 3 other owners have clearly diverged at this point. And so everyone probably needs to get their own lawyer. One of the model rules is rule 4.2, communication with person represented by counsel and dealing with unrepresented people, rule 4.3. So, you know, it's unclear, the lawyer here, do they represent, you know, all 4 of these owners, just the tick? And so I think it'd be really important for everyone to get their own counsel and make sure that their interests are represented.
Mark, what do you think?
Point 4 here is the most critical. They filed without joinder or consent of all other mall owners. That's problematic. I wonder if they lacked authority to even put this into a bankruptcy, and whether or not there was an individual that was able to sign the petition on behalf of the debtor. That's a major concern. And I don't know what their org docs look like or what the structure may have been, but it's certainly possible that absent an independent director, someone that had authority to file, they may have exceeded their authority, which would have put the attorney that filed it in ethical hot water, because that certainly isn't a meritorious filing if they didn't have the authority.
But Mark, what if we change the fact pattern? What if the debtor was not in a receivership and had been receiving 2/3 of the proceeds received from the shopping?
Yeah, I think it changes a little bit. I don't think it changes significantly. I think at that point, they're using the bankruptcy code to potentially pause the collections proceedings, to pause the enforcement of the debt, and attempting to use that cash during the pendency of a restructure to get to a conclusion. I think it softens the ethical issue slightly, but open to what others are thinking.
And Matt, what do you think?
I agree with Mark. It changes it a little bit. One of the facts for me is the original loan was 30 million. over a 10-year term. Presumably that was the loan to buy the mall and operate it. They're down to $3 million owed. So that tells me there's probably some equity in the property. The fact that there's maybe some equity in the property, assuming the mall is still operating at least in some fashion, maybe there is a reasonable chance of reorganization. And so that may tip the scale in favor of that there may be a good faith reason for the filing, even without having those people on board yet. If they've been receiving the funds, then that tells me maybe they're current on the loan. The bank hadn't started requesting, all the payments, that sort of thing. So it does change it to me, but I don't know how much.
Samantha, what do you think?
Yeah, I agree. It at least shows that maybe there's some potential to actually reorganize, but it would also be interesting to know how much they're actually receiving in cash, if it's a really small amount, maybe the mall's not actually doing well at all. Then, and if it's insignificant, then I don't know that it changes anything really.
And Samantha, what about one more here? What if the other tenants in common had joined in this bankruptcy? How does that change the assessment?
Yeah, I think to Mark's earlier point, I think it would definitely help, especially if someone was fighting this and said, no, you actually don't have the ability to even file this. It's a factual analysis. The court's going to look at the totality of the facts. But, even if all of them had signed, you would still probably be having a fight with the lender. So it could be the same outcome.
And Matt, what do you think?
I agree with Samantha again. I guess I'm just agreeing with everybody this time. It probably has the same outcome if there's if all of them are on board.
Mark, you have anything to add here?
Not a thing.
Okay, then we'll go back to Matt to pick up model rule 4.3, dealing with unrepresented persons. How would this model rule come into play with this case?
So this one, Samantha referenced it earlier. Here, I think it would potentially apply to those three other entities that also own or have an ownership interest in the land if they're not represented. 4.3 just sets out some duties for the attorneys who are communicating with unrepresented people to essentially make sure that person knows, I don't represent you. I'm not protecting your interests. I've got my own client. They're the ones I'm here to protect. And potentially advise that unrepresented person to get represented. I think especially in this case, you're talking about $3 million debt still out there in the receivership. And it would honestly be surprising to me if by the time the bankruptcy case is filed, those three aren't represented by somebody already. But assuming they weren't, then 4.3 would kick in.
Okay, let's go to the next case study here, which is Intervention Energy Holdings, LLC. And this one is on slide 29. This background, the creditor had been granted a single common unit in limited liability company, an LLC, which moved to dismiss a Chapter 7 case on behalf of the LLC on grounds that pursuant to an amended limited liability company agreement, unanimous consent of all unit holders was required for commencement of a bankruptcy petition on the LLC's behalf. There was a holding where bankruptcy court judge Kevin J. Clearly held that the agreement between limited liability company or LLC and creditors to which it was indebted as a prerequisite to the creditor's forbearance in not exercising its rights in connection with the LLC's default, whereby creditor was granted a single common unit interest in an LLC, and the limited liability company agreement was amended to require unanimous consent of all common unit holders. Commencement for a bankruptcy case on the LLC's behalf was void and against public policy. So, Samantha, what do you see as the ethical issues that would be in play in this situation?
So one of the model rules is applicable here. It's model rule 1.1, which deals with competence and says that lawyers need to have legal knowledge, skill, they need to know what they're doing when they, act on behalf of their client. And one of the key concepts in bankruptcy is that ipso facto clauses, most of them are unenforceable in bankruptcy. And what those say is that you can terminate a contract in the event of bankruptcy or insolvency. And so generally things that are sort of a backdoor way of standing in the way of bankruptcy filings are going to be viewed as backdoor ipso facto clauses that are not enforceable. And here the lawyer representing the creditor that filed this motion to dismiss would need to do some due diligence and research to see whether this is even viable. And like Mark said, it's usually difficult, factually to get the court to rule on your behalf in these situations. And so, this creditor was a minority equity owner, more so a creditor than an equity owner in my view. And the court took note of that and said, this creditor has no duty to anyone but itself. So the lawyer just needs to be careful about, advising their client about, the success of this type of motion.
And Mark, what do you see as the ethical issues in play here?
I'm not sure I'd file it here. I don't think this is your one to take a chance on. And I know that for me, I'm not sure I'd put my name on it. That's not, this is not the right fact pattern to kind of go in guns blazing.
And Matt, what do you think? Is this one to put your name on?
So Mark's talking about putting his name on the motion to dismiss. My name would be on the bankruptcy filing itself. I would probably take the chance on the bankruptcy filing because of the outcome that Judge Carey ruled in the case. I think some of the sort of changes to the fact pattern that we may get into outline why under these facts I would be comfortable filing the Chapter 11 case. I'm probably less comfortable under some of those other fact patterns, and I can come back to that in a minute.
Sure. So with that, we'll take it to Samantha and change the fact pattern. Samantha, what if the person refusing to consent to the filing was an independent director or a manager who was required to be appointed as a condition to the mortgage loan being funded? How does this change the assessment?
So independent directors owe a fiduciary duty to the company to, possibly its equity and unsecured creditors if there's insolvency. And so they can't just block a bankruptcy if it's not consistent with their fiduciary duty to the company. So they would have to really examine the situation, the financials of the company, and determine whether that was the best option for the company. And they have to act on an informed basis. So I think if they didn't consent, that could be bad for them.
Good point. Matt, what do you think?
So I agree with Samantha on the sort of fiduciary duty aspects that independent director has. It's always somewhat ironic to me that they call them independent directors. They're appointed by the creditor to be an independent director. How independent actually are they? And that's where the conflict usually comes up. But from a debtor's attorney standpoint, if I do have a so-called independent director who is saying, I do not consent to the bankruptcy filing, and the corporate documents give them that power, then I'm thinking a little harder about whether I file the bankruptcy and sort of thumb my nose at that creditor saying, look, I dare you to come in and do something about this. There is, in the Ninth Circuit at least, there's a case that actually sanctions the attorney for the debtor for filing a Chapter 11 case without the corporate authority that was necessary. And it wasn't an independent director situation like this. It was just a small company that had multiple members, and a couple of the members said we don't consent, and they filed it anyway. And so because of that case, I would be a little more hesitant to say, I know the independent director has the authority to block this. They have blocked it, but I'm going to file it anyway. I would probably take some other step to get it, and maybe in that case, I'm seeking a receiver be appointed over the company and giving that receiver authority to determine whether to file a bankruptcy case, and then telling them that's what needs to happen to get around the independent director's review.
Thank you. Mark, you have anything to add to this change in fact pattern?
Matt, the last little tweak that you gave, and that you would, on behalf of the debtor, seek to appoint a receiver over the entity and then talk to the receiver and have the receiver file. That's great, and I think that circumvents a lot of the ethical issues that you'd be dealing with here. For me, as a creditor's lawyer that's dealing almost exclusively in CMBS and non-recourse carve-out loans, you would trigger full recourse against the guarantor 6 ways to Sunday. So you would have not only the agreement to the appointment of a receiver, but directing the receiver to take action that could potentially delay the creditor. Ooh, we'd have some fun going after that guarantor. So that would be something to keep in mind as debtors counsel, that you'd want to make sure that your guarantor has separate counsel in that circumstance, because the interests of the guarantor are most certainly not aligned or even close to aligned with that of the borrower.
That's what I was just gonna, that's a whole different ethics issue between, you know, representation of the company that needs to file the bankruptcy case and then the guarantor who's got a whole different interest in not having it filed.
Absolutely. And that's a good just general reminder here, is that when you're dealing with single asset cases and you're dealing with these types of small, closely held real estate companies, oftentimes the debtor and the guarantor are very similar. They're often this management of the guarantor is the manager of the borrower, and there's a lot of overlap. That shouldn't negate the need for there to be 2 separate attorneys looking at this from the guarantor's perspective and from the borrower's perspective. And we find that a lot of the attorneys that get in and attempt to do both find themselves in a lot of hot water, especially when you're dealing with non-recourse carve-out. If you've got continuing unlimited guarantees from a traditional lender, wherein if they default, everybody's liable for everything anyways, maybe you can get away with a joint representation. But when there are such different requirements in non-recourse carve-out financings, you're going to really want to make sure that the individual guarantor or the corporate guarantor is getting some good independent advice as to how to proceed.
And changing the fact pattern here is we're at our 4-minute warning. Matt, what if the creditor also owned the majority of the interest in this LLC?
I think that changes. So you're no longer just a one single common unit or even an independent director. The creditor is the majority owner. At that point, the governing documents of the company may give that creditor the unilateral ability or the veto power over a bankruptcy filing. If it does, and they're the majority owner of the company, I don't know there's a whole lot I can do as a debtor's attorney to overcome that. That's what the agreement says, right? And that was there since the time that the creditor was the majority owner. So from an ethics standpoint, that becomes very interesting because I'm representing the company, not the majority owner. Creditor probably has their own attorney who's the one pushing for not filing a bankruptcy case. So there's a whole minefield of ethics problems for me as the company attorney. But it does change the equation, I think.
Mark, anything you want to add to this one?
Nothing here.
What do you got? Any other additional perspective from you, Samantha?
No, I agree with Matt. I mean, in that case, the creditor would be wearing 2 hats and might be able to block the bankruptcy. And the court in this case really focused on, look, this is a minority owner. It's basically a creditor. So maybe that would have changed the court's analysis.
And Samantha, while you have the microphone, please review for us briefly, with the 2-minute warning here, how Model Rule 1.7 conflict of interest current clients might come into play here.
Yeah, so Rule 1.7 talks about concurrent conflicts of interest, which, result from when a lawyer represents, they have responsibilities to the client, a former client, or a third person. And so this goes back to a point we've been talking about a lot today, which is who is the client. And if I was debtor's counsel here, I'd want to be very clear about who I represent, particularly given this creditor has ownership interests. You don't represent every, you got to be careful with who you represent. You don't represent every creditor either. So just being clear about who your client is.
All right. Well, we're about out of time here. Would welcome any final thoughts from the panelists about how the model rules play a role in their practice. Mark, do you have any parting thoughts for us on this?
Continue to do the right thing, and you're always going to be in good standing.
Great sound bites. Samantha, what can you add?
Yeah, trust your gut. If something feels off, it might be.
And Matt?
The only thing I'll add to what these two just said is if your gut tells you one thing, but your mind tells you something else, call the bar counsel's office. The people there will answer questions for you. We've done that several times when it's like, hey, I got this thing that I don't know if it's okay or not. They'll tell you their view on it. And I find it really hard to believe that they would later pursue you for an ethics violation for doing exactly what they told you was okay to do. So use that resource if you need to.
Great points. Well, panelists, we all appreciate your time very much. We are now out of time, and this concludes our webinar. You saw we spent a lot of time talking about the model rules, so we encourage the audience to review the full text of the model rules in slides 38 to 42. Thank you for joining for another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks, everyone. Take care.
Thanks.
David.